So good morning, everyone. My name is Carrie Ramsay, and I am the project manager for the Weekend Project at Queen's University. And for those of you who haven't heard of us before, we are funded by FedDev Ontario through the Women Entrepreneurship Strategy. And it's been an exciting time to be sharing these different workshops with you. Certainly, online during this time of COVID-19, there's been a lot of different shifts and changes. But one thing that has remained the same is that businesses continue to be started. Businesses are certainly pivoting, and one of the interesting aspects that we're going to talk about today is really getting a new invention, a new product off the ground. And I can't think of anyone more fitting to be talking about that today than Angela Lyon, who is a patent agent with Queen's Partnerships and Innovation team. And she's one of my colleagues, and so I know her well, and you're in for a real treat today. One of the things that I'll just mention as we start is perhaps you'd like to find your chat button, which for me at least is in the bottom middle of my screen. You should see a chat button, and just let us know where you are connecting from today. We love to find out who's in the room, and that just helps not only for myself, but also for other participants who may wish to reach out and follow up. This, of course, is also meant to help build a peer network of women entrepreneurs. And I hope that you, throughout this workshop series that we've been holding the past couple of months, have managed to connect with some women, even outside of the workshop situation. And we're so grateful for those of you who continue to appear on our screens. And of course, welcome to those who have never been to one of our weekend online presentations before. So without further ado, I would love to turn over today's session to Angela Lyon, and she is going to talk to us about first things first, landmines to avoid when developing inventions. So Angela, you have our full attention.
Thanks very much, Carrie. Just to check, can you hear me okay? Yeah, okay. So just welcome to everyone, and thank you very much to Carrie for the invitation to talk about developing inventions. And just so you know, I'm going to gear this talk at a beginner level. Some of you might find that it helps you to understand what questions that you should be asking, and that's my goal today. You know how they say it's the unknown unknowns, the things that you don't even know that you're unaware of that can trip you up. And so today's talk is geared at a beginner level to go through a bunch of different things, just to call your attention to whether you need to ask questions in that area. So just to give a very brief intro to why I'm invited to talk about this topic, I'm a registered patent agent in both Canada and in the United States. And many of you may not have heard of this profession, patent agency. I certainly hadn't. It's a nice job where you can straddle science and the law. You're sort of got one leg in both camps, and you can work with inventors in order to write patent applications. So it's a lot of scientific writing, but you also engage with patent examiners. And so that is a lot like legal writing. And so it's really interesting. I love it. I've worked at Queen's University for a long time. I trained there to be a patent agent, and then I went on to get fully registered through the Canadian Intellectual Property Office. And the nice thing about that is the US Patent and Trademark Office allows other countries like Canada's registered patent agents to represent Canadian residents in front of the United States patent examiners. So I can sign the documents, prepare all the arguments and everything for both Canadian and US patent prosecution in order to get an issued patent from an application. Now, if I wanted to actually represent inventors in court and sue people for infringement, I would have to go to the career from law school. So you can actually approach it as a scientist and become the type of person who works with inventors to write the application. That's what I did. Or you could go to law school and then represent the inventors after they have an issued patent to either sue people that you think are infringing your patent or represent whether the patent that they have is valid when the bad guys come and try and break their patent in court. So it's kind of got two types. There's patent agents and there's patent attorneys, depending on whether they went to law school, but we all go through the same professional, huge exam in order to get accredited. So that's what I am. I'm at the university in the technology transfer office, which is the little office that deals with inventions and tries to patent them and then contact companies to see if they would like to pay for the rights. Okay, I'm going to move to the next slide. I hope. Okay, here I am. And that's just a little bit about me. I do have a chemistry background, although I work with inventions in a variety of areas. And I put a nice picture of my kids, which are 3 boys, and my partner, Paul, who's a wonderful help to me. Okay, so I already introduced that this is a very introductory level. And if you have more questions about your particular situation, please feel free to contact me after the talk and we can get into more specifics about what types of advice that you need. Now, I don't want you to get confused about what I said about patent agency and patent attorneys. I am not a lawyer. This is not legal advice. I work in intellectual property and I meet with baby companies quite frequently to talk about all the different steps, but I'm a patent agent and I don't want you to think that this is legal advice. And it's quite possible you're going to need more specific advice. Like I said before, I'm just trying to whet your appetite for what types of questions to ask. Okay, I want to start at a topic that I find people who are just at the very beginning of developing ideas or starting companies are often confusing. So I just want to clarify. You might think that you want a particular name, either for your product or for your company. In fact, I often meet with people and they're already really in love with a name. And I find this is very similar to, you know, when you go shopping for real estate, big mistake to fall in love with the very first house that you see, because of course you might not win the bidding war or whatever happens and you'll be heartbroken, and then you look at the next house and you're heartbroken. And it's the same thing with naming either your product or your company. Try not to fall in love. That name, that word might already be trademarked by another company, in which case they own that term. And we'll talk more about trademark in a couple of minutes, but you may be prevented legally from even using it. You can't start a business and put up on the web that this is what you're going to call it unless you've done a trademark search to make sure that you're not infringing on somebody else's property. So you might have gone to just a search engine like Google and typed in your name. I don't know what it is. Let's say ShamWow, right? You've got this chamois, you've decided to call it ShamWow, and you go to Google and there's nothing on Google. Nobody's got ShamWow. Please don't be confused thinking that that means that the term is available. Trademarks may or may not be on the web. I mean, I know Queen's University owns quite a few trademarks. For example, they own the word liberator from like the 1980s. And we have no presence of the word liberator to do with Queens anywhere on the web. However, we own the term in Canada. Nobody else can use it without our permission. So there's an example of someone who actually owns a term, but it's completely absent from the web. So don't feel that Googling is enough. Another thing here, this second bullet is the domain available? So often people who are interested in starting a new product or a new company, they want to see if, you know, shamwow.com or shamwow.org or .net or .ca, is that World Wide Web address available to you? And a lot of terms, domain names are already taken. There are companies that buy up everything that they can think of They don't actually want it. They just want to own it so that when you fall in love with the word and decide you have to have it, you'll pay them for that domain name that they have already purchased. So domain availability is a separate question. It doesn't have to do with trademarks, but it's something that you might want to look into. Now, the other thing you may have heard of is a nuance search, this third bullet. This is, for example, if you decide to form a company and you go to see a lawyer to get incorporated, the lawyer will do a nuance search. They have to see if the name that you're thinking of for your company is available, or if there's already a company, say in Ontario or even in Canada, depending on what region you've decided to incorporate in. You can't have more than one business called McDonald's. You'll confuse the public. So there's this search engine called Nuance where you have to pay a fee in order to search all the company names and see if the one that you've chosen is available to you. And it's quite possible it's not available. You need to be able to pivot and not fall in love with your first idea, as I mentioned. Okay, now we're going to talk for a few minutes about trademarks. And before I get started, I want you to know I'm okay if you want to put any questions in the chat. Carrie will interrupt me and let me know that you have a question. I don't want you to feel like you have to hold it all to the end. I'm happy to talk about things that my audience is interested in hearing. So please feel free to do that. Okay, I'm going to turn now to the next slide, which is a website that you should probably jot down. It's Global Brand Database. If you type in those words into any search engine, you're going to go to the World Intellectual Property Office. You can see how it says WIPO right here, WIPO IP Portal, World Intellectual Property Office, Intellectual Property Portal. And this one is about trademarks. Now I'm going to just orient you to two different things here. Let's go over. Carrie, can you see my cursor circling things? No?
No. We could just see
okay.
the slide.
Okay.
At least I can't.
That's fine. So you'll notice in the middle of this slide, there's sort of two sections, left and right. The left one says search by, and then text, image class, and goods and services. And on the right, it says filter by. I want you to look at the filter by right-hand side section for a minute. If you click on CATM, which you can see is highlighted there, and then you click the filter button down at the right, which is navy blue there, you've selected that you only want to look at trademarks from the Canadian Intellectual Property Office. And I think that's helpful. I mean, you can start your search with, I don't want to filter on a particular country. I just want to see the whole world for this ShamWow word that I'm searching. However, you're going to get a ton of hits. Like there's going to be all kinds of use in Singapore and, countries that you probably aren't going to be marketing in. So you can look all over the world, but it'll bog you down. You might be looking at all the hits for a couple of hours and get kind of exhausted. So I suggest as a starting point that you click on the CATM, just limit yourselves to Canada, go down maybe to the US alphabetical zone there in that list, click US also, then hit filter. And you'll notice I've already done that in this screen capture. You can see just under the word filter in this light blue zone, you'll see a box that says source CATM USTM. So it's showing that I have filtered down to just Canadian and US trademarks. And then I went over to the left side into that search by zone, and under text, I would type ShamWow or whatever term you're wondering if people already own and you need to see if you can start using it or if you're actually infringing on somebody else's trademark. So you would type in ShamWow and then hit search. And I hope that's clear. I mean, you can really play on this website with a whole bunch of different ideas. And so I don't want to do it for you. I want to enable you to be able to play and see what's going on with your term. Now, just so you're aware, we could also search a figure. Let's say you drew a koala bear on a tree and you want that to be the symbol for your t-shirt company, and all the t-shirts are going to have this koala bear on it. You need to see if that koala bear drawing is really close to one that is already trademarked. Now, the other thing I should mention about trademarks is they're field specific, which is really interesting. So for example, a gasoline company might already have a koala bear, but you're interested in putting it on clothing and sportswear, sweatpants and t-shirts, and that's okay. They have different fields for trademarks. You can probably think of an example of like Tony the Tiger breakfast cereal, but then also one of the oil and gas companies has a tiger as their mascot, and it's on a lot of their advertising. And there was actually a conflict in court about that, and the judge decided that the public is not confused between breakfast cereal and gasoline. So it's fine for you to both have tigers. So I haven't given a lot of talk about how to search a symbol, but you could always email me afterwards and I can go through that. It's a little bit more challenging than text searching.
And can I put out a question real quick?
Yeah.
Just as others are probably thinking and absorbing as well. But my 16-year-old son started a summer business this year. Oh, just go back to the previous slide.
Okay.
He used this because you shared this with me at one point. And so we didn't understand the filter part because we're not, smart like you. And so we just looked under the search by. So he put the text, he put the name of the business he wanted to start. And then just over a few tabs there, it says country. And so he put Canada. So instead of on the filter side, he put the country on the search by. And so that actually, I don't know if that gives the same results. I suppose that's my question.
And so I haven't used that, but it certainly appears to be. I can't really say, but we could do a comparison.
Yeah, it appeared to give him.
Find that out.
Yeah, it appeared to, and the interesting thing was that what you said, his business is BuzzBox Fun Kits for kids. Well, there was a BuzzBox, but it was an alcohol company, and so again, the two aren't competing, and that's what the results gave us. So it was great to have that as an exercise, and just I thought I would throw that out there for someone like me who's not maybe understanding all the filters. I actually he used the country tab, and there might be ways to use that search bar, which it's a really useful tool. Thanks for sharing it.
Yeah, no problem. And I just, your example reminds me that sometimes it's a good idea to do a search to see what products are associated with that word. Like if it's huge in the cannabis field, you might want to steer away from it if it has to do with, I don't know, children's candy. Those are different fields, but you don't want the public to steer away from your candy product because that term is really well known for cannabis. So I would warn that you not only search the word that you're thinking of, but words that sound like it, different spellings. You might, if you've got it as two words like that We Can program that we are currently talking to you under, put it together, put it apart. What sounds like it? You really want to investigate what people could be confused by so that your product stands out. Yeah. And I'll just draw your attention to, in the search at the bottom here, you'll see that I actually did put in We Can and then captured the first few things that were found. In the leftmost column, it says We Can, which is what we searched. And the second column says USTM. So it's showing you whether it's a US trademark or a Canadian trademark. The third column is saying whether it's active or inactive. If it's inactive, it's dead. Like it used to be trademarked, but they're no longer paying to keep it in force. So it's not a worry to you anymore. And now I want to walk you all the way over to the second to last column on the right, which is called niche class. It is the field, like, are these people also selling sportswear? Are they selling, children's toy boxes? What field do they use that term in? And so if you didn't have any idea what niche class you were, you could easily Google it. And there's not very many of them. You could sort of walk through them going, oh no, I'm not legal services and I'm not this and I'm not that. And you can sort of get an idea of which niche class you are working in. And then you could pay attention to the ones that come up in your search that are also in the same niche class that you believe that you are. Okay, why should we bother with intellectual property? We're going to talk about patents, and we're already talking about trademarks. There's copyrights, there's designs. We're going to talk about what those all mean. But I thought I'd start with why bother? I mean, if you have a great idea, maybe you should just give it to the world. Wouldn't that be nice if you just blog about your new cure for cancer and give it to the world? Well, the thing is that a lot of investors are not interested in supporting an idea unless there's some kind of monopoly. They don't want, to invest in your company if as soon as you get it up off the ground, everyone else is going to start selling that product also because you haven't got any kind of protection wrapped around it. Now, this slide is decorated with a few marks just to grab your attention. You no doubt recognize the Coca-Cola thing, and so that's the type of thing that is trademarked. Not only the words, but the shape of it, like the scroll, the way it's presented is probably also trademarked all over the world. Apple's mark, I mean, you know that customer loyalty, as soon as you walk into Best Buy and you're like, where? Oh, there it is. That's what I want to buy. I definitely want an Apple product. And so it's a way of marking your product so that customers who wish to support you and buy your product again can easily recognize it. That's the type of reasoning behind having a symbol or a word trademarked so that other companies cannot infringe and mark their similar product with the same name. Kleenex is kind of a funny story. They, of course, invented this brand new word, Kleenex, which was not a word in the English language. And unfortunately, their trademark has been what's called diluted because we walk into the grocery store saying, I need the Kleenex aisle. We call everything Kleenex, whether it's that company's product or whether it's just any old tissue. And so that's unfortunate for them because they have this recognizable symbol, but we don't limit ourselves to just buying from them. It's like jacuzzi. I mean, if you've got a hot tub, I might walk over and go, oh, great jacuzzi. And it doesn't matter whether it's the jacuzzi company's product or not. They've had dilution of their trademark. Everybody calls it that. Another thing just to bring your attention to, at the bottom of this slide on the right are the two Queen's School of Business symbols. So the one on the left, Queen's School of Business, is how they went for many, many years. And they had a trademark in a variety of countries to try to promote the existence of their School of Business. Now, a couple of years ago, they had a donation from an alumnus who, as a contingency on their donation, insisted that the school change its name. The person wanted it to be named after them. And unfortunately, their name is not that unique. Even in the area of schools of business, there are more than one Smith School of Business. So this is unfortunate from a marketing point of view. You can see how Queen's really tried to retain the way that their mark looks so that it's very similar to what that recognition from the public that they had already created. They tried not to lose it through a name change. Okay, I think I'm going to move on from that. It does make the point of why bother with intellectual property. It helps you with a monopoly. It helps with brand recognition, and it creates a barrier to entry. For example, if your next door neighbor sees that you're like buying Ferraris and Lamborghinis and your business is doing very well, there's a bit of a barrier to them starting to sell the same product because you have some kind of legal teeth. You've got a patent, or you've got a trademark, or you've got a design. And so there's a barrier to them copying you. Okay, how am I doing time-wise? Not too bad. Okay, so you've made a discovery. Now what? Well, it would be good for you to do some searching. And I understand that searching is not, it's probably a new thing for you. I want to introduce you to how to do a little searching. And then on the next slide, I have a recommendation for a professional searcher in case you're interested in having more depth to the search. And if you hire a professional, of course, it doesn't take very much time. They don't have to learn the system of how to do it. So you want to know if anyone else has thought of this before. And in particular, you want to think about what problem your product is solving and how is it already solved. Like, if you've discovered a new style for a can opener, you want to look at all the other ways of opening cans to see if yours is too similar to one that is patented. I mean, you can't infringe somebody else's patent. If they have a valid patent in Canada, you cannot sell a can opener that is a copy of theirs. So in addition to talking about how you can get intellectual property, I want to warn you that you have to check if other people have intellectual property that is blocking you from being able to sell. I don't want you to get a cease and desist letter in a few months after you start using a term or selling a product. I want you to know enough to check whether you're going to have any repercussions of using a term or selling a particular product. So here I suggest going to Google. There's Google Patents, which is a great database. There's also some free patent sites, Patent Lens and Free Patents Online, and you could do some searching there. Also, the United States Patent and Trademark Office website has made a big effort to be user-friendly. So you say it's a can opener, you can go on that site and just search with keywords can and opener, and you're going to get some hits of patents or applications for patent, and you're going to be able to see what other people have done in that area. One of the first landmines we're hitting is you have to be very careful about talking about an idea. If you're thinking of patenting it, you could actually start the clock on the patent timeline without knowing it. For example, if you went to a trade show and you had a booth and you were saying to people, what your product does, that could actually prevent you from getting a patent in the future, because on that date, you publicly revealed your idea, or maybe you even had it on display. So the US and Canada allow you to talk about your invention, and then you have 1 year to file it in the patent office. But most countries of the world, you must go to the patent office first. If you've revealed it at all, you will never get a patent in Europe, Brazil, India, all kinds of countries will fall away as soon as you reveal your invention. So you have to be very careful what appears on your company's website about new products that are coming out. If you're thinking of patenting, you need to do that part first if you want the potential of going into a lot of countries. And then the third point here is, great, you've got a new idea. Does anyone actually care? Just because it's a neat thing, there may not be a need for it. And we've seen this at my office where people come with disclosures and we're like, well, this problem is already solved by this product. It's very different than your idea, but it's in the market. It's not expensive. What is your big advantage of doing it your way? There's no need here. Okay, so this is a professional searcher based out of Kingston, Brian Chenoweth. Brian assists us on many cases. He has, years of searching experience. And I just put as a header on this slide a line that I learned when I was in graduate school, which is, don't let 3 months in the lab replace a half an hour in the library. You know, when I was a chemist, you'd want to throw things together and try to make new molecules. But if the way to make a target molecule was already all worked out in the library, it's crazy to use the manpower hours and the, you know, materials. All of that costs a lot of money. And it could be you sort of banging your head against the wall for 3 weeks trying to make this molecule, when really, if you had just done a little bit of library work, you would have found that that molecule was already made in the world, published, and all the instructions were right there. And so this is a very similar thing. If you've got an idea and you're worried that you might be infringing somebody else, you can learn how to search it. But even if you don't find it, I suggest that you might want to have someone like Brian do a quick search to really check whether it's already been done before you incur maybe $10,000 of patent expenses, depending on who you use to help you. It's very easy to go through money quickly in the intellectual property game.
Angela, we do have a question somebody sent me here. Cynthia, I'm just reveal. Cynthia has a question about, which I think is really timely. How does the public disclosure limit affect people who use crowdfunding sites? Because we know that crowdfunding, like Kickstarter, for instance, is a really popular method of raising money to get your product off the ground. But in a way, you're disclosing that publicly. So how does that affect the time limit, I suppose, that you've just talked about?
Yeah, good question. If I was advising someone who wanted to do crowdsourcing and put something on their website about a product that is not yet finalized, for example, they don't have the prototype made, I would suggest that they leave out the secret sauce of how the item works, if that's possible. If it's a very predictable thing, like, you know, hardware where everybody knows how hinges work and that kind of thing, then putting the picture on the web of what you intend to make could certainly prevent you from being able to patent it in the future. So you have to be very careful. But if, for example, you have an idea like, you know, how to clean municipal water, how to get, you know, COVID-19 out of municipal water systems or something, you know, brand new, and nobody really knows how you're going to do it, I would caution you not to put the actual how you do it details in any kind of disclosure, including crowdsourcing. Okay, here's just a few bullets on the steps when you're thinking of developing a new idea. I highly recommend that you do some market analysis, like I was talking about. Is it just meat, or is there actually a need? And it's always recommended that you go out and talk to customers in order to see what their complaints are and what their needs are. I mean, I've even seen a presentation where it's like, if you want to form a company, don't have any ideas. Go out and find out what customers need, then come back to the drawing board. I was like, oh, that's really interesting. You know, what are people willing to pay for? What do they need? As I mentioned, why is your idea better? You know, if there's already a solution and it's not cost prohibitive, why would people switch to using your idea? Okay, so now I want to throw a term at you, which is freedom to operate. And I've already talked about it. Is there intellectual property, either trademarks or patents, that block you? You cannot do what your idea is because there's a patent in force in Canada about that exact same thing. And so that would mean you do not have freedom to operate. I would also recommend that you do an intellectual property landscape analysis, which is basically looking at all the search results. You want things that are really close. If you feel like, oh, I searched can openers, I found nothing. Like, oh, that makes me really worry about what you missed. You know, if you've got some kind of part of the can opener that is special, maybe we need to look for that type of mechanism in other fields, because the patent examiner certainly will. And the next one is commercialization strategy. How are you going to bring this to market? Are you interested in developing inventions. And then what we do in the tech transfer office is often we contact companies who are already working in that field to see if they would like to license the intellectual property. That's one commercialization strategy. Sometimes we have intellectual property, excuse me, and we form a company. Sometimes we even bundle different intellectual properties, similar, some kind of relation between them, and we'll form a company and start getting the idea off the ground. And we're not contacting larger companies to see if they want to license it. We're basically developing it from the ground up. Patent drafting means meeting with someone like me to write out the details of your invention. And I'll be interested in your search results, and we'll probably augment your search because we want to really be able to define how your idea is different from what's already known in the world. And then we do the filing, which means we pay the fee and put the documents into the different national offices, the Canadian, the US. There's also a World Intellectual Property Office, which sounds great. I mean, it would be fantastic if you could get an issued patent that's an international one. But in fact, it's a way of delaying getting an issued patent and intentionally sort of seconding your application for another year and a half before you enter different countries' patent offices. So it's a way of grabbing the date in the law, but not proceeding quite yet. You don't want all the money of having to file in all the different countries' offices. You just want to file in one office and have it stick there for a year and a half while you develop your investors, or maybe make your prototype and get some testing done, some kind of work in order to raise capital. Yeah, and then, so that was a lot about filing a patent. And then prosecution means the back and forth between your patent agent and the examiner. So the examiner looks all over the world for any kind of document that has the elements that you've described about your invention. And they're looking to knock you out with two fatal blows. One is called novelty. Is there a single document that has every single element of your invention? It's probably going to knock it out for novelty, which means it's not a new idea. It's already known. Here's a document. And then the second argument that the examiner will use is obviousness, which means not one reference, but a combination of references have every element of your invention. Now, sometimes I can argue back about obviousness. I can say no one would look in such hugely separate fields in order to combine these elements into one. But sometimes obviousness can bring you down. You know, you can't always argue over it. And then if we succeed in describing your invention so that it doesn't overlap what's already known, and convincing the examiner that it's novel and not obvious, then we will proceed to getting an issued patent. And that's when you actually have legal teeth to prevent other people from either making, using, or selling your invention. The last bullet on this slide is venture creation and or licensing. We talked a bit about licensing, and then venture creation is basically trying to bring in investment and in a variety of models in order to support your business. Okay, I'm just going to look at the time. My next slide is a bunch of different types of intellectual property. And of course, trade secret is not going to be on it because it means you don't get any kind of protection on it. You merely keep it secret. And I just want to warn you that trade secrets are wonderful as long as you can keep the secret of how your invention works. So you really have to limit how many employees in the company are aware of all the details. You know, you might have to keep the core secret sauce of how you do the invention under very tight wraps. Listerine is an example from the 1880s of a secret that the developer's family kept for a long time. And eventually, the recipe was purchased by a pharmaceutical company, and of course the laws changed where you really had to reveal what was in a pharmaceutical product. It's not like the 1880s where it could be, you know, Dr. McGillicuddy's elixir solves everything. And so the secret came out eventually. You know, the companies had to list the ingredients right on the label. And the trade secret, the actual document that the inventor had signed over to the pharmaceutical company, said, as long as the company is making money off this recipe that was developed by, you know, John Smith or whatever, then a portion of the sales will be returned to him or his heirs. And so the company actually, even to this day, continues to pay because the secret was not revealed by them. They were at no fault. And the recipe is indeed still being sold and revenues being made. And so a portion goes back to them. So for them, it worked out well. But for you, I really caution you about trade secrets, because one disgruntled employee who takes off and goes to work for your competitor could blow how you solve the problem that you solve, and you can't put the genie back in the bottle. It's impossible for the secret to go back. Once your competitor is aware of it, they could even file a patent application on it and end up preventing you from being able to practice your own invention. Okay, so we're just going to talk about different types of intellectual property, some of which you know a little bit about now. Patents are what I do, often called utility patents. Copyright is a way of protecting text. For example, certain characters in a certain order presented exactly that way. So for example, copyright is common for a poem or for a song. It's also a way of protecting computer code because it's the exact characters in that order that you want protection for. The thing is, for copyrights, don't be confused. People can sort of lift the idea out and write it their own way, and they wouldn't owe you any money. It's only the exact thing that you've created, like a song or a poem, in that order. That's what copyright protects. Trademarks we've talked about. It can be either a symbol like that koala bear, or it can be a term, a short amount of words like sham wow, or you can think of Nike's just do it, that kind of short term. A design registration is sometimes nicknamed a design patent, and it is the way that something is shaped. So for example, if you came up with a vase that could be industrially reproduced and it's a cool shape, you could protect it under design registration. And the only weak point of design patents are that if anyone makes any slight change to it, they don't owe you any money. It's only sort of that exact shape that you've protected. So just as an example, you can think of Coca-Cola's iconic bottle shape. They have that exact shape protected because they don't want, you know, other competitors to be able to sell products like, you know, Pepsi in exactly that shape because it would confuse the public. I'm not going to talk much about these, but you can also protect circuit topographies and new plant varieties that have been developed. There's one trademark agent in Kingston, Rob Murata. And so Rob is available for consultation if you were interested in actually getting a trademark for a term. Trademarks cost money. You might be happy to just search and make sure no one else has it, and then you can actually start to sell your product using your term, like ShamWow. In trademarks, unlike patents, you can actually start using it and then trademark it later. But if you wanted to consult a trademark agent to find out what the cost would be, or, you know, any kind of advice, then I would recommend Rob. Okay, so a patent is an exclusive monopoly, which is the ability to exclude others from making, using, or selling it. And it's not every single way that you describe in the whole patent application. It has to do with how it's claimed. And the claims are at the last section of a patent application. And they're the part that you really need a patent agent or a patent attorney to assist you with. It's the It's single sentences that define your invention very clearly and exactly without leaving out any essential part. And that is what has to stand up in court later if you were suing someone else for infringement, or if the bad guys were coming after you to try to invalidate your patent. It's all about the claims. And so when I say here that a patent has to do with the claimed invention, it's, you know, as those single sentences come out at the end of the fight with the examiner, when they've looked at how you originally cast the net of your wording, you know, maybe you went for every kind of fastener in the world, and the examiner came back with, you know, these references talk about nails and screws. And you're like, okay, I'll get rid of fastener. I'll tighten the language up. Just, you know, Velcro, staples, you know, a subset of what a fastener means. And eventually you get to a point where the claim is exactly as it issues to patent. And that's what you would have a monopoly on. And patents are good for a limit. Yeah, go ahead, Carrie.
Sorry, someone just had a question about cost. And I'm not sure if you're going to cover, are you going to cover that later in terms of, and I should insert, and you might want to refer to the fact that the great thing is WeCan clients do have access to you and some other intellectual property specialists we also have on the team at no cost. And so there, if anyone, and she'll mention later, wants to contact her, you could actually have a consultation with Ange. But the actual filing of the patents, et cetera, does cost. Yeah. Do you want to give them an idea of that? Someone's asking, what does it cost me to file a patent?
I will. I think I'll just mention it on the next slide because it'll make more sense. I'll just finish this one and then we'll talk cost. Right. So I was saying the patent, once you get it issued, is good for a limited period of time, and it's in a particular country. So the limited period of time is 20 years from the time that you file it originally until it will expire. And in a specific country is to remind you that just because somebody has a US patent doesn't mean that they have a patent in Canada. It's very country specific as to whether they have a block in Canada, for example. So I know a lot of people look and they're like, oh, they have a US patent, and so they just assume that they also have a Canadian, but they may not. We can do a quick search for you. Okay, here's a timeline. So on the left-hand side, there's an arrow at the 0-month mark where you file a very first patent application. And if you wanted to save costs, you're allowed to file what's called a provisional, which is a very informal, could be a couple of PowerPoint slides. It can be very quick and dirty if you wanted to. I don't recommend the quick and dirty. It can bite you later. But if you're running off to a trade show and you want to just file some quick summary of your idea in the patent office, you could certainly do this provisional. The fee for the US Patent Office's provisional is, depending on the size of your company, if you have less than 500 employees, it's $130 US. That's the government fee portion. Now, if you were using a patent agent, it's labor, right? So it's going to be probably in the vicinity of $400 an hour for them to create your patent application. And so I recommend that you give them really good material to draw from. Some searching you've already done, some nice drawings explaining the difference between the known thing and how your thing is different. Anyway, we can talk about that more if you are interested in filing a patent application after. You can contact me and we can talk more about your particular situation. But anyway, $130 government fee, and then I don't know, maybe $2,000 or $5,000 if you're working with a patent agent because you're paying for their time. And we have the offer of labor-free assistance if you qualify under the WeCan program. And then the very next arrow, which is right on top of filing, is that you can publish. If you're running off to a conference and you're going to present it, you can file in the patent office the same day. But I highly recommend that you don't wait and file in the patent office after you've talked about it, because you've really limited the number of countries that you can get a patent in by doing it in that order. So try to file before you talk or same day as you talk. And then you'll notice at the 12-month mark, you have to file a more formal patent application. If your first one was the informal provisional, at the 12-month mark, it needs to be in great formatting, claims written by a professional, I highly recommend. And you file it. You could file it, for example, in the US and Canada. Maybe you want to do the European Patent Office. They have a regional office, so you don't have to work in each little European country. You just have one office that you hopefully get the examiner satisfied, and then you would end up choosing which countries to go into at the end after you've satisfied the examiner and you have an issued patent. At the 18-month mark, your application is going to publish. And this doesn't really have anything to do with you being able to get a patent one day or not get a patent one day. It's just an automatic thing. They will keep it secret for 18 months so that your competitor, unless you put it up on your website or blow it at a trade show, your competitor should be completely in the dark about your development of this idea. And then at the 18-month mark, it will publish on the web. They'll publish two things: the one that you filed at the 12-month mark, that formal, beautiful application, and they will publish the quick and dirty one that you may have filed at the 0-month mark, the provisional. Now, in between 18 months and around, I don't know, 24 to 36 months, that's when your agent is arguing with the patent examiners and hopefully getting them satisfied, bringing in the language of your claim so that it really just covers your invention and doesn't accidentally encroach on anybody else's. And hopefully you get a patent that issues. And cost-wise, I talked about the first filing. The 12-month mark filing is more formal. So there might be more labor costs depending on who you're using. And for the fee portion that goes to the government offices, Canada is $400 to file. The US depends on page count, so you should expect between $800 US and about $1,200, depends on the length of the document. And that's just to get started, just to submit them. Europe is more like $8,000 to $10,000. Yeah, we can talk about other countries offline if you're interested, but basically if it's a country where you have to translate your document, it's really going to increase the cost. So Japan, for example, it's going to be $10,000. China is going to be 5 to 8K. Yeah, so if there's translation involved, the costs increase dramatically. Okay, the criteria for a patent application is, we've talked a lot about this, you have to have novelty, it has to be not obvious, the claims have to make sense, and it has to be useful. It can't be, I made this thing, it has absolutely no use. Patents are for something that is tied to some kind of utility. There's a 20-year advantage to having a patent. You've got legal teeth to prevent others from practicing your invention. And you've got the law on your side. Disadvantages of patents are that it takes forever to get through the examination process. So for example, if you have a computer software, it's very likely that you're merely going to want to use copyright and not patents, because by the time you get it allowed, it might be 5 years later, and you're probably on version 4 or version 5. You know, like the first version is out of date at this point. So patenting can be really challenging for software. Also, the patents claims are really written in stone once you get the patent issued. And so as you tweak your prototype, you know, lessons learned and versions are changed, you can't actually keep up with the description in the patent of your product. So yeah, there's some disadvantages to patenting, but of course there are advantages too. If you're interested to find a patent agent, there's on the Canadian Intellectual Property Office website, they actually have a list with contact information. So if you just Google SIPO, find a patent agent, it'll come right up. And I would recommend that you look for someone who has experience in your particular area. You know, If you're working in the field of metallurgy, it would be nice if the patent agent knows about metallurgy and potentially has done graduate work in that field so that they really are aware of the terminology and can quickly understand what your innovation is all about. So I wanted to leave a little bit of time for questions, but again, I'll just mention that I'm available if you want to talk about your company's intellectual property and get reiteration on some of the advice around trademarks or how to use copyright to your advantage or patents or even designs. So thanks very much, everybody, and I open the floor to questions.
You should be able to unmute yourself, folks, if you would like to. I'll let you do that, or you can drop your question into the chat. Some of you might not want to reveal your idea to all of us. You just want to meet with Ange later so as to not start the patent clock ticking. But if there's any general questions, if there's anything general, we're happy to address it at the moment. And by we, I mean Ange.
Nice.
Hi, can anybody? Oh, here we go.
Yes, we can hear you, Cynthia.
Oh, lovely. What if you don't live in the region? I'm in Toronto. Is there something for this area, like a weekend?
Great question. So if you email me, my email address is in there. I can try to hook you up with a resource in your own area. There are a number of what we would call women entrepreneurship strategy projects happening across Ontario. So if you email me your region, I can certainly do my best to connect you with a resource in that area.
Lovely. Thanks very much.
No problem. Any other questions from the floor? For those of you who might have missed it, sorry, and I'll come right back. I did drop my email address, and I'll do that again. If anyone wants a recording of today's session, you can email me. I'll put that in the comments section again right now. Sorry, was someone going to ask a question?
I was just going to say this was really, really informative, and I really appreciate it. Thank you.
Great. I have one more landmine that you know how you forget to put it in the slides and then you wake up in the middle of the night going, one more thing. So it's one more point. I want you to think about whether your company owns the ideas that it is developing. And that might sound crazy, but let me give you a couple of examples. Let's say that you are developing some kind of computer code and you've decided to use open source as the source of code. So there can actually be rules associated with which type of open source coding that you've used. Some of them do not allow the code to be included in products for sale. So if you're using open source code, I highly recommend that you get in touch so that we can help you to understand whether you can even use that for your product. If you're using a consultant to write code for you, what's the consultant agreement say about the work product? Many coders have in their agreements that they want to be able to continue to use their work product after the project is over. That might not work if you believe that your company owns that work product. You paid them to write it. So you need to be careful about who you're employing and whether you own the rights to their work product. I know that it's similar when I got married for the second time. I wanted the photographer's copyright to the photos. I wanted her to take the photos, but then I wanted to own them so that I could, print the ones that I wanted to, instead of having to go through her where she retained the copyright and I had to pay a markup on every photo that I had printed. It's kind of like who owns the idea, the rights to the idea. You need to think about that for all of the interactions for developing your invention or idea.
So last call for questions. I know that we're at the 11 o'clock mark and I'm sure some of you are zooming off to other meetings. Go ahead, Brandy.
Hi, wait. I can turn on my video so it's a little bit more interactive. Hi, Ange. I'm I'm a brander, and I'm kind of looking into getting a little bit towards naming, because I often have a lot of people come to me and they're looking for their logo, and my plan is to start pivoting towards doing strategy work, which has included naming a little bit, and a few other times just maybe encouraging them that perhaps they shouldn't pursue the name that they have. And I think this is more in trademark. I've done a little bit of research, although that database is fantastic. I am so excited for that one. So I guess I'm still trying to formulate the question, but I wanted to hop on and at least try and ask it. So for trademarks, when there's a baby company that's not really interested in patents, so say they're not creating a new service, say it's something like you're talking about, like a photographer or a hairdresser or something like that, some sort of small business, how important is it to have a very unique name and to get that trademark? Because that's usually the barrier. And I find a lot of people, they're like, well, my name is unique enough. Usually it's a descriptor of where they live, and I try to discourage that, but it doesn't always work. And they just kind of move forward. And yes, I guess my question is, for that trademark zone, what do you think is the milestone at which people should proceed and those that should maybe just hold back? Because I heard you discussing that it's unlike patents, you can just kind of start and then adjust later.
So I usually caution companies to, they don't often have money to pour into trademarking at the beginning. I mean, trademarking, let's say ballpark $2,000 to get a trademark in Canada, and more like $4,000 to $5,000 to get the trademark in the US. And I'm not talking about just filing, I'm talking about the whole thing. 2 in Canada, around 5 in the US. And it depends how many niche classes you go for, so don't hold me to that. If it was a small company, I wouldn't want them to go to the huge expense of trademarking until, they have the money to spend. However, I would want them to do the infringement analysis to see if the mark is available, right? Like that doesn't cost hardly anything, and you shouldn't get known by, hummingbird or some word that you're not aware is already trademarked in Canada. And then you're going to have to go through the expense of a name change, the signage. There's all kinds of costs associated with changing your name. So best to prevent any kind of change being required. And then as for your question about the type of name, I agree with you that they may not know how big they're going to get one day. So they might not want to be associated with Inverary, Ontario forever, because they might take over the whole nation of selling this particular device, or they could go global, who knows? And so I personally, I'm kind of, I'm one of those literal people who loves it when I drive by the store and I can tell what they sell from the outside, like Toys R Us or thinking children's toys or whatever. Love it. When it says, JYSK and I have no idea what they sell there, I probably would never even go. I swear to God, I wouldn't even go because I'm sort of mad at them that they can't inform me at a glance. So yeah, I always prevent people from totally falling in love with a name that's personal to them, nothing to do with their business, but they want to name it after, their first pet or whatever. But that's just me. Some people don't want to be, really literal and tell people what it is that they sell. They really want to just name it after their first pet, and they can't be convinced, but I always try. I try not to have it be regionally associated. I try to put something in the name so that people are aware of what it is, so that they could find it on a search. If they're searching wool and knitting, they're going to come up with your business somehow instead of completely missing it because you've called it, Toto or whatever.
Yes, I understand that.
Did I miss part of your question, Brandon?
No, I think it's just a bigger discussion. But I think you answered the one which is pressing. I have like a lot of clients at the very beginning are, you know, they don't really even have several $1,000s to invest in branding, which they need to be able to make the money to do the other part. But I also want to make sure that they're making informed decisions from the get-go. So I kind of do the same thing where I caution them, like, if you're not ready to invest this, start making some income before you start branding, but at the same time, don't start calling yourself something and have to change, because even if you invest only a couple $100s on cards and, you know, $1,000 on a sign, all of that adds up to something you have to do.
And the market penetration, you know, people talk about you and they recommend you to friends for months and possibly years after your interaction with them. And if your name has changed, you miss out on that business.
Absolutely.
Yeah.
Thank you.
I'll just do a quick note. I just put this, I just put this into the chat, but Tommy from QBLC, Queen's Business Law Clinic, who I mentioned in the chat, has mentioned that they can also help WeCan clients to do the trademark search, prepare an opinion and file, and they only pay a filing fee of $330 per class. I'm not sure how that compares, Ange, you'd know better. Also, additional classes after the first class cost only $100 each. So suffice to say, there is a large savings of money as a WeCan client if you make yourself, if you connect with QBLC. Again, you have my email. I can connect you with QBLC if you're like, what's the, or Tommy, maybe you want to put your email address in the chat as well. But I'm happy to connect anyone here who's listening and wants to be connected. All right. Are there any final questions? It's all right if you have a question. Don't be shy. This is a great opportunity. All right. Going once, going twice. All right. I know that certainly many of you have written down Ange's email to follow up with afterwards. So on behalf of all of us, Ange, I want to thank you for putting a very complicated topic into laywoman's terms so that we can all understand it. And I think also appreciate that there's a lot more to naming and starting an invention that some of us might have previously anticipated. So thank you so much. By the way, I see Tommy has put her email into the chat as well. Oh, no, you put it into me privately, Tommy, so I'll share that as well. But we'll make sure that everyone gets connected who wants to be connected. And on behalf of all of us, thank you so much.
Oh, you're very welcome. Have a great day, everybody.
Enjoy your day, everyone. Take care.